Arizona voters head to the polls. How can artificial intelligence help with government transparency? An update on a gun ID lawsuit. Michigan's Line 5 pipeline permits, the best and worst schools across the country, and more. Welcome to the States, powered by the Center Square. It's Tuesday, July 21st, 2026. I'm your host, Greg Bishop. Polls for Arizona's primaries are open until 7 p.m. Mountain Standard Time today. Democratic and Republican voters will be deciding on primaries for the gubernatorial nominees. Now, Arizona Governor Katie Hobbs awaits to see who her opponent will be in that November election. But polls suggest it's likely to be Republican U.S. Representative Andy Biggs. Now, the Democratic governor is running unopposed in that primary, and Biggs and another Arizona Republican, U.S. Representative David Schweikert of Scottsdale, they're vying to be her opponent in the November general election. Now, Arizona Republicans, they'll be heading to the polls and also deciding today on who takes on State Attorney General Chris Mays in the November 3rd general election. Arizona Senate President Warren Peterson and Attorney Rodney Glassman are competing in the Republican primary. Mays, the Democrat, running unopposed in the Democratic primary. Now, Republicans and Democrats also running for Arizona State Superintendent of Public Instruction, a role that could shape education policy in the state. Now, on the Republican side, incumbent Tom Horn and State Treasurer Kimberly Yee are competing for that spot. While on the Democratic side, certified behavior analyst Brett Matthew Newby is running against Teresa Libia Ruiz, the former president of Glendale Community College in Maricopa County. Now, there are also primaries across the state for various congressional seats for either party, with candidates recently having debates about things like housing, healthcare, and immigration customs enforcement and immigration law. Again, polls close at 7 p.m. tonight local time. For early results this evening, be sure to go to thecentersquare.com/Arizona. We'll share some of those results tomorrow here with the States.
Ensure that Americans receive better services from their government?
Well, we're encouraging them to use AI to do important work that they might be underway. We're sharing best practices with them from other parts of the agencies that we get a bird's eye view of. We're pioneering it ourselves with regard to ways that we can assess what spending is consistent with the administration's policy agenda.
So that was Director of the U.S. Office of Management and Budget, Russell Vogt, earlier this month discussing how they're using artificial intelligence in the federal budgeting process. On a state level, North Carolina State Auditor Dave Bullock, he told the states that they're using AI in their auditing process, and he said it's like throwing jet fuel on their progress to track how tax dollars are being used in North Carolina. But where else can AI be implemented in government to bring about more transparency and accountability? Well, to delve further into that question, let's talk with Jeff Wolff, Senior Director of Technology Partnerships at Reveal. Jeff, thanks for taking time with us here on the States. So how can artificial intelligence improve overall government transparency?
AI can be used for a lot of things that you see both in the commercial sector as well, but summaries of emails, documents, creation of briefs, budget creation, improved workflows. But with all of that comes additional information that it becomes requestable, right? So one of the challenges I don't think we talk about enough is everyone's starting to use artificial intelligence to speed up workflows, to provide more efficiency in government. But AI interactions also create additional government records themselves. So AI prompts, responses, policies, meeting summaries, emails, all of that becomes discoverable depending on state public records laws. And that's one of the things we focus on here quite a bit.
So when it comes to the overall process, is it possible that AI can help in automating requesting public records?
Yes, we actually provide tools on both sides of the house for that very purpose. So AI is becoming more useful not only to government agencies and state and local governments to help respond to requests, but also helping citizens provide better requests in the first place. You see tools now that help shape a citizen's request for a public records offering, making sure that they're not asking questions that are not scoped well, providing more consistency in the request, clear timelines for what they're looking for, also deflecting their requests that have already been made by other citizens to documents that already exist in the public sector.
Now, last month, the Center Square reporting across the country, our reporters requested records from the Colorado Attorney General's office, but the information was held behind a $330 paywall. Other public records that were requested were being held behind a $290 paywall. Now, for nearly 2 months, the Colorado AG's office declined to answer how those fees were being calculated. Then, just last week, Jeff, the AG's office told the Center Square it wants to charge a total of $5,130 for those same requests, an increase of over $4,800 compared to the initial estimate. Can artificial intelligence address, maybe even reduce, if not eliminate, such kinds of costs?
Absolutely. One of the challenges we have, obviously, in the United States is that we are dealing with 50 different Freedom of Information or Public Records Acts, depending on the state that you're in, not to mention the federal government's own FOIA Act. So every state has a different, they have a different set of deadlines, a different set of exemptions, to your point, a different fee structure and different response requirements. That being said, the workflow is the same for the most part from state to state, from municipality to municipality. It's making sure that the documents are available, they're identified, they're reviewed, they're redacted, and they're produced. Regardless of the governing statute for the state, there is a standard workflow, and artificial intelligence can help at every step of that chain to reduce what was typically done with manual research, document printing, photocopying requests, things that the state's laws allowed for. The problem is that a lot of the state's laws have not been updated yet to accommodate the speed with which AI can now help those agencies do that work.
So we've heard a little bit here about how artificial intelligence can kind of help facilitate and speed up such requests, but there's got to be some risks involved here,
Sure.
right? What are those risks?
It's really comes back to transparency, right? So citizens judge transparency less by the statements that are made, but more by how quickly and completely governments respond to the requests they make. For example, if a request takes 6 months and, to your point, costs thousands of dollars or requires manually reviewing hundreds of thousands of files, people don't perceive government as transparent. Modern technology can reduce that burden, but it's not all about that. It's also about trust in the records that they're getting. AI can be used to the point I made, deflect some requests that are redundant. It can help concatenate and identify documents that are similar to make it easier for reviewers to quickly get through those documents. We're already seeing AI being used in our tools for document review, to deduplicate repeated records, to search across the hundreds of thousands of collated records that they're producing for some of the larger requests, to more consistently do redactions in conjunction with the requirements of their state statutes, and to quickly produce the resulting documents out in a defensible way with an audit trail that they can follow. So all of that transparency exists in the tools that they're using, and that workflow has to be the same that's shown to the government, to the citizens, so that they have more trust in the process.
Jeff, AI obviously is advancing at a pretty rapid rate. I mean, I've
Yes.
always thought about, AI video, and I don't know if you're familiar with the Will Smith spaghetti progression, right? First, Will Smith spaghetti eating looked ridiculous, and nowadays it looks like it's filmed on a Hollywood set somewhere. So clearly AI is advancing, but when it comes to these types of records with sensitive information of maybe victims with a police report, or certain types of trade secrets with a company that may be working with a state agency, for instance, how crucial is it that any finished product that artificial intelligence produces on a Freedom of Information Act request, that there is some kind of human oversight?
A human always has to be in the loop. But that being said, the traditional workflow for public records is collect the records, have all human eyes on every document, and redact what you need to redact for privacy laws, for state statutes, and then produce the results. Humans make mistakes. What is nice about using artificial intelligence to assist in the process is that the AI can take a first stab at those reviews, at the redactions, and then a human can vet or sample the results of that. And so therefore you can get the documents that are needed in a quicker time frame at a less expensive rate, but with a higher degree of accuracy. But still, you always have a human reviewing that work at the end.
So, Jeff, what other opportunities are there? We've been talking about AI being used for more government transparency, started the program with even the federal government looking at how to use AI with their budgeting process, and auditors in states using AI to help with their auditing process. What other opportunities, at least, have you seen being in this space?
So I think you'll see a lot more conflagration of other tools. Every major product that is used in a workforce environment, whether that's corporate or public sector, is intersecting with our large language models and products, commercial products like Claude from Anthropic or ChatGPT from OpenAI. They all have connectivity to them so that the large language models can actually interact with the data productivity tools. I think you're going to see a lot more of that in the future, so that you can compare the work you did in your email calendar to what you put on your Slack or Teams environment, communications that you're having, or the budgeting requests that you're working on can interact with the efficiency reports that were already done very easily. So I think the next phase of this is much more agentic work, where AI can actually do tasks as opposed to just answering questions or doing one-off content generation. But it can actually perform tasks for us in a variety of the tools that we use today, speeding up general work.
So, Jeff, finally here, what should various, taxpayer-funded agencies do, like state, local, federal government? What should they consider before they look to deploy these types of tools?
I would say, first of all, they need to invest in the technology. We work with a lot of municipalities who see the advantage of using tools to be more efficient and transparent to the citizens that they support and serve. I think they need to vet the technologies that they're going to purchase, make sure that they are built to standards that allow for the AI to function, but within guardrails. It's extremely important. And I think they just need to make sure that the tools that they're using are used by similar types of municipalities and government agencies already.
Jeff Wolff, Senior Director of Technology Partnerships at Reveal. Greatly appreciate you taking the time here for the states. We'll be right back with more.
One problem is the law says not only do you need to apply for and be issued the FOID card, but you have to have it on you at any time that you possess a firearm. And he objects to that. That's a situation where essentially the government can ask you for your papers to see if you are someone entitled to exercise a right. And that, too, is not how rights are supposed to work in this country.
That was New Civil Liberties Alliance Senior Litigation Counsel Jacob Hubert back in May, telling us about the lawsuit that they filed on behalf of 3 Illinois residents challenging the state's firearm owner's ID card in federal court. Now, last week, the state of Illinois and Cook County denied allegations that the state's FOID card deprives everyone of their right to keep and bear arms. A timeline for the case is being proposed. Welcome back to the States. I'm Greg Bishop. And while I was out on vacation last week, the Illinois State Police Director and the Cook County State's Attorney, they provided a federal district court answers to the allegations made by plaintiffs' attorneys suing the state over the FOID card. Now, don't confuse this with other lawsuits challenging Illinois gun laws. Separate and individual cases challenging the state's gun and magazine ban could be decided by the U.S. Supreme Court next year. This FOID card case being filed in federal district court by plaintiffs against Illinois State Police Director Brendan Kelly, Illinois Attorney General Kwame Raoul, and Cook County State's Attorney Eileen O'Neill Burke May 19th. On June 12th, the state and Cook County asked for a delay in responding to those allegations. That was granted by a judge just a few days after. And then on July 13th, the state and Cook County, they filed their answers to the allegations that the law was unconstitutional. Yesterday, a joint status update was provided. We'll get to that a little bit later. But here's what the answers filed last week by the Illinois State Police and the Cook County State's Attorney had to say. So attorneys for the plaintiffs that were suing over the FOID card, they say the law deprives everyone of the right to keep and bear arms, including the right to possess a firearm for self-defense in the home, unless and until they seek and receive the state's permission. They also allege to possess any type of firearm and ammunition in Illinois and anywhere for any length of time, one must obtain the FOID card, the requirement to initiate an administrative process, with all the burden being on the individual wanting to exercise their Second Amendment right. Now, the state police and Cook County, they denied those allegations. The plaintiffs sue over the FOID card. They also say that the FOID card prohibits the exercise of a fundamental right unless and until they apply for and receive the state's approval, something they say violates both the Due Process Clause of the 14th Amendment and the Second Amendment. Again, the state, they say that's not true, and they deny those allegations. The plaintiffs further alleged in their initial complaint specifically that they want to obtain a firearm for self-defense, but they refuse to submit to the state's procedure. The state replied that defendants deny that the FOID Act imposes an unconstitutional procedure. Now, they further denied other allegations and said that the defendants admit that plaintiffs purport to bring this lawsuit to seek relief described, but deny that plaintiffs are entitled to any relief. Defendants admit in their answers to the plaintiffs' questions that Illinois law states that if the director or director's designee within Illinois State Police denies a record challenge pursuant to state law, the petitioner cannot request an administrative hearing, but rather the director shall render a final administrative decision, which shall be subject to judicial review under provisions of the administrative review law in Illinois statutes. Now, plaintiffs, in their initial complaint, they allege the FOID Card Act does not require the review board to provide an in-person hearing with testimony, cross-examination, or even arguments, though the board has provided for non-public hearings at which an applicant, upon request, may present evidence and be represented by counsel. State police, they said that they admit the law allows for, but does not require, under all circumstances, that hearings where a petitioner may be represented by counsel and present evidence relating to their request for relief, but they do deny the remaining allegations as part of that particular allegation. Now, plaintiffs, they allege the review board applies easier criteria when deciding whether to grant relief to active law enforcement or whether to deal with certain types of mental health treatment questions. They say that the officer need only show that he did not act in a manner threatening to himself or others, sought evaluations as a result of his work, and was not treated involuntarily or admitted to a mental health facility for more than 30 days or more than once in the past 5 years. Now, state police, they just simply say they deny the allegations in that paragraph. Now, further in this filing to the federal district courts, the plaintiffs say that under the FOID scheme, the states deny all residents the right to keep and bear arms unless and until they satisfy the Illinois State Police that they're eligible and reserves the right to revoke permission instantly at any time. State police, they denied that allegation. Defendants, they said they deny the plaintiffs that Christopher Lawrence and Kim Dalton have been injured. These are two plaintiffs that want to get firearms for self-defense, but don't want to have to comply with a state law they feel is violating their rights. And the state police, they admit that the third plaintiff, Justin Tucker, does indeed possess a valid FOID card. A revelation state police rarely do, but they did make that revelation in state and federal district court. Now, the defendants, Illinois State Police and Cook County, they deny that the plaintiff, Tucker, has been injured. The plaintiffs say Illinois' FOID card requirement injures Tucker for an additional reason that before his card expiration, he'll be required to submit a renewal application and pay the fees to continue to be allowed to possess any firearm or ammunition for self-defense in his home upon his card's expiration. State police, they deny that allegation in that particular point. Now, one thing other that is important to point out here is this series of questions. If you look at close to the last page of the filing, at number 60, individuals have a liberty interest in their right to keep and bear arms in the home for self-defense. The defendants, Illinois State Police, quote, deny that allegation. They also deny that a state must provide due process before depriving them of fundamental constitutional rights, but later they admit that fundamental constitutional rights may be denied without any process whatsoever, but they deny further allegations about depriving rights. Now, the state further provided their affirmative defense. They say plaintiffs do not have standing because they have not suffered harm from the defendant's actions. They also say the firearm owner's identification card is a constitutional shall issue licensing regime under New York State Rifle and Pistol Association v. Bruin. They also argue in their affirmative defense that the firearm owner's identification card is consistent with the nation's history and tradition of firearm regulation. So what's next? Clearly, these are allegations and answers that have been made in federal court. Well, on Monday, yesterday, plaintiffs and defendants, they filed a joint status update with the court, saying that plaintiffs' complaints asserts two claims under Section USC 1983, one alleging that Illinois Firearm Owners Identification Card Act violates the Due Process Clause of the 14th Amendment, and another allegation that the act violates the right to keep and bear arms under the Second and 14th Amendments. Now, plaintiffs further go on to say, in the affirmative defense stated in their answer to plaintiff's complaint, defendants, the Secretary of the Illinois State Police and the Attorney General, they raised three factual and legal issues, and that's whether plaintiffs have alleged injuries that can support their standing to raise their claims, whether the FOID card is a constitutional shall issue licensing regime, and whether the FOID card is consistent with the nation's history and tradition of firearm regulation. Plaintiffs anticipate written discovery and potential depositions regarding the defendant's administration and enforcement of the FOID Act. Defendants anticipate written and depositions and discovery regarding the plaintiff's standing, including their alleged qualifications for a FOID card and the harms they allege in their complaint, as well as the administrative and enforcement of the FOID Card Act. Defendants also anticipate comprehensive expert discovery related to the history and tradition of firearms regulation in the United States. So how long is this going to take? Now, plaintiffs propose in their joint status updates August 3rd as the deadline for disclosures. Defendants propose August 21st, 2026 as the deadline for their initial rule disclosures. Defendants propose a deadline for plaintiffs' expert disclosures and delivery of expert reports by April 1st of 2027. So months away. The deadline for defendants' expert disclosure and delivery of expert reports, May 1st, 2027. Again, months away. A deadline for supplemental expert reports due May 15th, 2027, and expert discovery expected to be completed by July 2nd, 2027. Now, defendants have requested a jury trial to answer these questions from plaintiffs suing the state. Parties anticipate that a trial would last no more than 4 days. We'll be watching the docket closely on this case and other challenges against gun control laws across the country. Have you got something on your radar you'd like us to pin for further coverage? Be sure to leave a comment below. We'll be right back with more from the States.
The state law allowing the construction of an underground tunnel for Line 5 was approved back in 2018. If Democrats hadn't railroaded this for political purposes, it would be done by now. But nearly a decade later, political activists, by which I mean some of Michigan's own elected leaders, continue to fight it. The dangerous delays in this replacement project jeopardize our energy security and leaves a 70-year-old pipeline at risk of failure sitting under the Straits of Mackinac. The best thing we can do to lower energy prices and protect the environment is to let the Line 5 replacement project move forward.
That was Michigan State Senator Thomas Albert. Back in April, he proposed an amendment to state law. He said the amendment would prevent state officers or state departments from spending taxpayer dollars on lawsuits or other efforts aimed at blocking the Line 5 project. He said that would create a dangerous delay. Well, that amendment failed, but despite that failing, permit approvals were recently granted, representing a significant step forward for a project that's faced legal and regulatory disputes since it was first proposed in 2018. Joining us to discuss this is the Center Square reporter, Elise Apel. Elise, the Line 5 tunnel project, what is it?
Yeah, thanks for having me on, Greg. So this tunnel is a 73-year-old pipeline. It currently moves 500,000 barrels of oil and natural gas liquids daily under the Strait of Mackinac. So the Strait of Mackinac is about a 4-mile waterway that connects Lake Michigan and Lake Huron and kind of divides Michigan's lower and upper peninsulas. This is a pipeline that's currently just kind of sitting on the base of the lake bed there in Michigan. And they are trying to, Enbridge is a Canadian company that runs the pipeline, and they are trying to move the pipeline under the lake bed, drill down and put it in a tunnel that runs under the lake bed instead of just sitting kind of on the bottom of the lake bed. So it's been a project, like you said, that they've been trying to move forward since 2018. It's had a lot of hiccups, faced a lot of lawsuits, a lot of pushback from Democrats, from Native American groups, but this is really, just another step towards it actually coming to fruition.
Yeah, and again, just some of the particulars about this. The Line 5 tunnel, it's a 73-year-old pipeline, 500,000 barrels of oil and natural gas. You said a day? That's a significant amount of energy piping through there.
Yeah, and that's what Republicans say. And Democrats and these Native American groups are they're not just calling for the pipeline to remain as is, but they're actually calling for it to be closed completely because of the threat that they say it poses to the lakes and Michigan's natural resources. Republicans have pushed back against that and and the company Enbridge as well are pushing back against that and say that it's an important step to protecting Michigan's energy. The company, we spoke to the company, the Center Square spoke to the company, and they told us in a statement that the permits are an important step forward for a project designed to further protect the Great Lakes while helping ensure the uninterrupted flow of energy that supports Michigan and the region. So they really understand, that this is a significant issue for Michiganders and, how they get their natural energy.
And let's talk a little bit about that permit that was provided from the Michigan Department of Energy, Great Lakes, and Energy. You've got a 16-month review process with, 70,000 public comments. And what ultimately did they say, and what were some of their concerns?
Yeah, so the agency said that they would issue this permit. Now, there are more permits that still need to be released, so this is not the end of the road for permitting. But the agency said that, as proposed, the project met regulatory and statutory requirements. It did impose some conditions, though, because they had some concerns with lake irises and then some bat habitats in the area, so some concerns about a couple of the kind of more endangered species in the area. And so they imposed a couple kind of conditions, asked that Enbridge kind of basically protect those species, but it did end up moving forward with the permit process.
Now, as you said, Enbridge indicating this is an important step forward, but there's some that are pushing back against this, who may have been behind some of the efforts to halt this project from moving forward. Tell us about the Bay Mills Indian community. What did they have to say about the permit approvals?
Yeah, so that is one of the tribes that's been kind of fighting this tunnel, and it's one of the tribes that has been pushing for the tunnel to be closed completely, or the pipeline to be closed completely. So multiple Native American tribal nations and climate groups have also joined together. Both, they were criticizing the permits, but also for the last couple of years, they've kind of filed these lawsuits against the pipeline and the proposed changes to it. The Bay Mills Indian Community President Whitney Gravel said in a statement that the state of Michigan has betrayed us today. Every swimmer, every boater, every fisher, every tribal nation, and every Michigander who loves these waters. This decision to grant the permits is a deep betrayal of our Great Lakes state, and we will confront it immediately, fiercely, and without hesitation. So they really are, promising to continue fighting this.
That leads me to my next question, Elise. What's next for this? How long do you think that process is going to take? If there are challenges brought, any other hurdles there are to further permits, and when exactly is this project going to be complete?
So the real answer is no one really knows. The permit there's still a number of permits, both state level and federal level, that the project is waiting for. There's currently a lawsuit before the Supreme Court over a separate permit that some of those groups have filed, and they're basically litigating it before the Michigan Supreme Court, and a decision is expected on that in the next couple of weeks. So that could be another, either a step forward for the project or kind of another hurdle for them to pass. But really, all of this is just, in the context of President Trump's an executive order that he passed on day one declaring a national energy emergency. And so this project has really been expedited since that order was issued. And under that order, Trump asked that basically these projects nationwide kind of work to quickly solve high prices and remedy what he called numerous problems with America's energy infrastructure. So that's really kind of the background that's really pushing this project forward, and trying to lower energy costs, and really just expedite what President Trump has called an energy emergency. So that's kind of the background to this project. But really, who knows when it'll actually break ground. And even Enbridge itself, seems to be pretty hesitant on, giving a timeline for when they think that'll happen.
Yeah, it's something we'll definitely be checking back in with you on in Michigan. But let's maybe, hope it's not going to be another 8 years where we're still talking about permitting processes. Elise Apel with the Center Square, greatly appreciate your time. This is The States. We'll be right back after this. Which states has the best and worst schools in the country? Consumer finance website Wallet Hub crunched some numbers and delivered their list. Welcome back to The States. I'm Greg Bishop. Wallet Hub says securing a child's academic success begins with choosing the right schools. Now, to find the best, researchers with Wallet Hub compared all 50 states and the District of Columbia across 32 different metrics. While some research includes academic outcomes as their main metric, Wallet Hub says their analysis goes a bit further to look at performance, funding, safety, class size, and instructor credentials. Now, after crunching all those numbers, experts with Wallet Hub found the best states in the country for education starts with Massachusetts at number 1, Connecticut at number 2, New Jersey at number 3, New Hampshire at number 4, and Wisconsin at number 5. What about the worst states on their list? Well, Wallet Hub shows that 47th was West Virginia, 48th Oregon, 49th Oklahoma, 50th Alaska, and 51st New Mexico. Keep in mind, they also reviewed schools in the District of Columbia. Now, when it comes to dropout rates, the lowest states were in Mississippi, New Jersey, Connecticut, Alabama, New Hampshire, and West Virginia. The highest dropout rates, they were found in Alaska, Washington, Oklahoma, New Mexico, Idaho, and the District of Columbia. Further drilling down on other things like academic outcomes, for math test scores, the highest were found in Massachusetts, Utah, Minnesota, New Hampshire, and New Jersey. Arkansas, West Virginia, D.C., Alaska, and New Mexico had the lowest. What about test scores in reading? Well, they were the highest in Massachusetts, New Jersey, Colorado, New Hampshire, and Connecticut. The lowest reading scores were found in Delaware, Oklahoma, West Virginia, Alaska, and New Mexico. Another factor they looked at was pupil-to-teacher ratio, just how many teachers there are to students. And the highest ratio was found in Vermont, D.C., Maine, New Hampshire, and North Dakota. The lowest ratios found in Florida, Alaska, Nevada, Utah, and California. One that piqued my interest a bit was the percentage of threatened or injured high school students. The lowest rate was in Delaware, California, North Carolina, Maine, and Massachusetts. The highest percentage of threatened or injured high school students was in Idaho, Texas, Kansas, Alabama, Mississippi, and Louisiana. Now back to the states that was the highest across all categories. That was Massachusetts. Wallet Hub says Massachusetts boasts some of the best test scores in the country and ranks first in the nation in all core academic subjects for 2026, 4th and 8th grade reading and math scores. Now, students at high school level also do well. Wallet Hub says Massachusetts has the highest share of schools in the country who received a score of 3 or better on an AP exam. AP exams, they say, are high school classes with college-level work that are scored on a scale of 1 to 5. In addition, schools in Massachusetts are generally safe. Wallet Hub said Massachusetts has the 5th lowest share of students who report being threatened or injured with a weapon on school property, the 3rd lowest share who have been in a physical fight at school, and the 4th lowest share of who reported illegal drugs being available to them on school property. So which state are your kids enrolled in? And where does that state land on this ranking? Be sure to leave a comment below. We'll check those out. We'll be right back with more from the states. Welcome back to the States. Now it's time for America's Talking, with headlines from across the country you can find in the description below or in your inbox with the Center Square newsletter, free at thecentersquare.com. Pennsylvania Governor Josh Shapiro applauding the state's recent budget deal for providing a 100% increase in funding for rape crisis centers during a ceremonial signing at the YWCA Young Women's Association. The Center Square reporter Julia Kramer reports in the new deal, state funding for Pennsylvania's 47 rape crisis centers increased by $12 million. While many Republicans question if the budget was genuinely balanced, Shapiro maintained that the plan and its prioritization of survivors was a bipartisan effort. While giving a voice to survivors was a central theme of the signing ceremony, Shapiro also took the time to sternly critique those he believed failed to use the voices that they had already been given to address the issue.
I've been very, very clear over and over and over again that the conduct of the Senate Republican leadership to cower in the face of opposition from the Catholic Church and the insurance lobby is cowardice, and it's shameful. And they need to put this up for a vote. And when they do, there'll be over 40 votes in favor of opening up a window. It's time for them to act. Unfortunately, their leadership hasn't put it up. So I'm going to continue pressuring them to get it up for a vote. And if they don't, maybe hopefully the Senate will have new leadership who will put it up for a vote.
And while budgeting logistics currently keep the investment stuck in Harrisburg, taxpayer funds are expected to become available for distribution soon. Wisconsin voters could be subject to prosecution and their vote not counting if they place a wager on a prediction market on election results and then attempt to vote in that election. The Center Square reporter John Stife reports the Wisconsin Election Commission noted 2 state statutes, one which states that someone cannot vote in an election after wagering on the results, and another that says it's a felony to intentionally vote in an election that they are not qualified to vote in. The commission specifically named Kalshi and Polymarket as notable prediction markets with the option to wager on election results. The predictive markets, they say that they are different from sports wagering because the markets, they're peer-to-peer instead of placing wagers where the company holds the other side of the wager. The Elections Commission said a voter who wagers on a prediction market and then votes could be subject to voter qualification administrative challenges, and cases could then be referred to a district attorney. More than 500,000 people attended Atlanta's World Cup matches and fan events, according to the Metro Atlanta Chamber of Commerce. The economic impact numbers expected to be released in the next few weeks, but the attendance at the games and the FIFA Fan Festival Atlanta reached more than 500,000 people, according to the chamber. The 8 matches played at Mercedes-Benz Stadium attracted 544,500 fans and more than 500,000 people. About 27,000 daily attended the fan festival. Now, the games began with the June 15th game between eventual World Cup champion Spain and Cabo Verde and ended July 15th with a match between England and Argentina. Spain and Argentina played in the final game of the tournament Sunday at MetLife Stadium in Rutherford, New Jersey, with Spain taking home the trophy after a 1-0 win. The Center Square Associate Editor Kim Jarrett reports in Atlanta, the Metropolitan Atlanta Rapid Transit Authority, known as MARTA, said 4.7 million people rode the passenger rail system during that 35-day period. And Louisiana Insurance Commissioner Tim Temple urging residents to review their insurance coverage and prepare their homes as Tropical Depression 2, which is expected to strengthen into Tropical Storm Bertha, moves toward the northern Gulf Coast. The Center Square, Louisiana editor Misty Castile reports forecasters expect the system to gradually organize before tracking westward along the Gulf Coast, bringing the potentiality for heavy rain, gusty winds, and coastal flooding to southeastern Louisiana beginning Wednesday. While the storm is not expected to significantly affect the state through Tuesday, the National Weather Service says the greatest impacts expected Wednesday into early Thursday. Temple said Monday, regardless of how this storm develops, Louisianans should continue to monitor the weather and take steps to be insurance ready. He urged residents to trim trees, clear gutters and storm drains, secure outdoor furniture, and review emergency plans before conditions deteriorate. The National Weather Service has issued tropical storm and storm surge watches for portions of Louisiana's immediate coast east of the mouth of the Mississippi River, including eastern Orleans Parish. Forecasters caution that watchers could be expanded as the forecast evolves. And that's just some of what America's talking about. You can get those and other headlines at thecentersquare.com. From my studios in Central Illinois, I'm Greg Bishop, and you can join us back here Wednesday for more stories impacting you, the taxpayer, from across the country, only with the states, powered by the Center Square.